This video is entitled, Judgment Creditors Can Take This From You Unless You Outsmart Them. And in the next few minutes, I'm going to show you exactly what they can seize and the one structure they absolutely hate because they can't touch it, even when they win. So let me start with a question that might sting a little. If you lost a lawsuit today, how much of your wealth could someone legally take from you tomorrow? If your heart skipped a beat, that's the problem, and you're not alone. High net worth individuals, business owners, doctors, real estate investors almost always underestimate what a judgment creditor can grab. And trust me, after 34 years in the asset protection industry and nearly 30 setting up Cook Islands Trusts, I've seen creditors take everything from vacation homes to brokerage accounts to collectible wine someone thought didn't count. So here's the promise. By the end of this video, you're going to know exactly what assets are vulnerable, how seizure actually works, and the single legal structure that makes even the most aggressive collection attorney throw his hands up and surrender. And here's the path that we're going to take. Simple, clear, and incredibly useful. What judgment creditors can seize, the full list, including the stuff people forget. How creditors find your assets, which by the way is creepier than Google Maps. What future assets they can take, even money you don't yet have, and state exemptions, why they don't protect high net worth individuals. Real case studies about what happens when you are prepared versus unprepared. The offshore structure my law firm uses that stops seizure in its tracks. So stick with me. In about 60 seconds, you're going to hear the one part of the legal process that shocks the people most. And hey, before we dive deep, if you value advanced real-world legal strategies from someone who has been in the field for 3 decades, make sure to subscribe. I'm the CEO of the Lawyers Limited Law Firm and our brand Asset Protection Planners. And we've set up more Cook Islands Trust than any firm in the world, so you're in good hands. All right, here comes the part most people don't believe until it happens to them. Winning the lawsuit isn't enough for a creditor. The court doesn't hand them a bag of your money. They have to go collect it manually. And that process is both invasive and extremely effective. Here's the sequence. Step 1, they file a motion for examination of judgment debtor. This forces you into a courtroom where, under oath, you must answer questions about your assets. Under oath equals no hiding, no lying, and no, I forgot about the gold coins behind the Costco-sized bag of rice. You must answer truthfully or face perjury, fines, or even jail time. Step number 2, they interrogate you. They ask, what bank accounts do you have? Where do you bank? Where do you own real estate? Any vehicles? Any securities? Any crypto? Any trust? Any expected income? Any memberships, equity, royalties, commission? If they're good, they'll even ask you whether your kids owe you money. Yes, creditors absolutely seize loans you make to family members. And here's the funny but not funny part. You don't have to volunteer information, but they know exactly which questions to ask. Step number 3, they file motions to seize what they find. And going back to the last issue, keep in mind, they're trained to know the question to ask to find everything that you have. So don't think that you can just hide, keep things secret. Doesn't work. So again, step 3, they file motions to seize what they can find. Once they locate assets, they can file writs of garnishment, writs of execution, liens, sheriff's sale orders, which leads to one of the biggest surprises. Creditors can seize almost anything you own, including future income that you haven't earned yet. So we're going to talk about that in just a minute. Let's get blunt. Almost everything is fair game. Here's what creditors routinely go after. Number 1, bank accounts, checking, savings, joint accounts, business accounts. If your name is on it, it's vulnerable. Number 2, investment accounts, brokerage, money market, REITs, mutual funds, hedge funds, ETFs, crypto on exchanges, all seizable. If it has monetary value, they can take it. Number 3, stocks, bonds, individual equities, yes. Corporate bonds, yes. Treasuries, absolutely yes. Even the super safe stuff isn't safe from judgment creditors. Number 4, real estate. Your home in some cases, rentals, commercial buildings, raw land, Airbnbs, even and especially the paid off property you thought was untouchable. Number 5, vehicles. cars, trucks, motorcycles, boats, RVs, even the golf cart you secretly love more than your car. Number 6, business ownership. Your membership units in an LLC or shares of a corporation can be seized or charged, making the creditor your new unwanted business partner. Number 7, physical valuables, jewelry, watches, collections, gold, art, firearms, luxury goods, all seizable. Number 8, expected gains. So this is the part that people never see coming. A creditor can seize money that you don't have yet. Commissions, royalties, bonus, tax refunds, insurance payouts, dividend checks, future partnership distributions. They can even attach your wages, yes, your future earnings. So here's where the humor meets reality. A judgment creditor can potentially take the money that you plan to use for a vacation you haven't booked to recover from the stress they caused. Okay, now you may be thinking, what about state exemptions? Don't these protect me? Well, kind of, but not really. Most states offer a homestead exemption, but often it's capped and very low outside of Florida and Texas and some other states. Some protection for retirement accounts, some protection for wages, a tiny shield for personal items, often under $5,000. So let me put it gently. State exemptions were designed for average households, not for people with 7 or 8 figure net worth. If you're a high net worth individual, your exemptions are too small, too limited, too inconsistent across states, and too slow to claim. The wealthier that you are, the more a creditor can reach. Now, this is a lot better with some case studies so we can see this in real life. Prepared versus unprepared. Let's look at 2 anonymized composite cases. As a law firm, we can't reveal information about our clients, but these are from clients we've actually helped over the years. Case study number 1, the unprotected real estate investor who's a successful investor, had 14 rental properties, primary residence, 3 LLCs, over $2.5 million in equity. He believed his insurance would protect him. Then came the lawsuit. Claim $4.8 million, insurance coverage $1 million. So exposure, therefore, $3.8 million. He had no trust, no equity stripping, no offshore structures. Within 11 months, liens were placed on every rental property. 2 properties were forced into a sheriff's sale. His wages were garnished. His creditor took his brokerage account. His retirement contributions were frozen. Not because he was a bad guy, not because he lost intentionally, because he didn't plan. Now here's case study number 2, the protected entrepreneur. Another client of ours, let's call him Christopher, owned a business valued at $9.7 million. A luxury home, several rentals, brokerage accounts. He faced a $3.2 million lawsuit over a contract dispute. But years prior, he contacted us. We had set up a Cook Islands Trust with a Cook Islands LLC inside of it. We placed key assets in that structure. So when the lawsuit hit, we executed the proper trigger. The trustee, a licensed bonded Cook Islands law firm, stepped in and took management of the LLC. The result? The U.S. judge issued orders. The Cook Islands law said, no jurisdiction here. The assets stayed protected. The client settled for a tiny fraction, pennies on the dollar, because the creditor had no leverage. Same country, different system, different strategy, completely different outcome. Okay, here's the shock factor. Creditors can seize future income. In this section I promised earlier, judgment creditors are legally allowed to seize future wages, future commissions, future business profits, future royalties, future distributions. So if you're a high net worth entrepreneur, this is devastating. Imagine spending years building wealth only for a creditor to attach your future bonus, your future consulting income, your future distributions from the business that you built. Asset protection is not just about what you own today, it's about everything that you will earn tomorrow. So this is why timing matters and why offshore protection exists. Okay, so what about hiding assets? Okay, let's clear that up. A lot of people call us and say, I want to hide assets from my future spouse. We're getting a divorce, blah, blah, blah. Okay, so they ask, can I just hide assets? And the answer is no, absolutely not. Hiding assets is illegal, unethical, and totally unnecessary. I mean, asset protection is not about hiding. It's about transferring ownership into legal structures you don't personally control during a legal attack. That's the difference. If you hide assets, you lose. If you structure assets, you win. And it's just that simple. Okay, so the offshore structure, as promised, that creditors hate the most. Let's talk about that structure right now. And this is the one that makes judgment creditors groan out loud. The Cook Islands Trust, represented by this purple box here, plus Cook Islands LLC combo, represented by this LLC inside of the trust. You create a Cook Islands Trust. That's a foreign trust, not subject to U.S. court orders. We place a Cook Islands LLC inside the trust. You're the manager of the LLC. There's you with your finger pointing. While the waters are calm, you maintain signature authority, investment control, practical access. So when the lawsuit hits, we change gears. We change so the manager of the LLC here, that's inside of the trust, goes to our trusted, licensed, bonded trustee company in the Cook Islands. So they do this temporarily. Why? Because if you control the assets during a legal attack, a judge can force you to turn them over, but they cannot force a foreign trustee company operating under foreign law to follow U.S. orders. And the Cook Islands law literally prohibits the trustee from complying with foreign judgments. Number 4, when the lawsuit goes away, you return to full management and you keep everything intact. People say, oh, well, what if they run away with my money? Well, I've been doing this for 30 years now. We've seen nothing but impeccable integrity. The Cook Islands is the most regulated trust jurisdiction in the world. And I have a Cook Islands Trust myself. The trustee company is the only signatory on it. And this is what happens. You don't lose control. You don't lose ownership, just protection when you need it. And that's how this works. This structure has protected billions over the past 40 years. That's how long the Cook Islands Trust law has been enacted, right about 40. And yes, like I say, my firm has set up more Cook Islands Trusts than any organization in the world. We've seen everything, and we know exactly how to build them properly, so protection. Okay, so who needs this? Who needs this level of protection we're talking about? You do if you own real estate. You run a business. You have employees. You give professional advice. You treat patients. You invest. You're wealthy enough to attract lawsuits. You live in the U.S., the most lawsuit-happy country on earth. And we also help people all over the world, by the way, not just the U.S., but all over the U.S. If you have $1 million to $20 million plus in assets, you're exactly the person that lawyers target. Why? Because you can pay the judgment. You have liquidity, you have equity. You have something worth chasing. Asset protection isn't paranoia, it's math. Okay, so what should you do right now? What should you do right now as you're sitting here or standing there or driving or whatever you're doing, watching this or listening to it? Here's a takeaway. A judgment creditor can seize almost anything you own, even future income, unless your assets are positioned inside of a structure they can't penetrate. If you're already being sued, time is limited. If you're not being sued yet, now is the perfect moment. If you want to learn more, you can feel free to go to assetprotectionplanners.com. My team and I will help you understand exactly what structure fits your risk profile and your goals.